Madam Clerk.
Oh yes, oh yes, oh yes. The Supreme Court of North Carolina has resumed sitting for the dispatch of business. God save the state and this honorable court.
Good morning, everyone. The court calls 300A93-3 State versus Best. Justice Irvin is recused. Ms. Johnson.
Thank you. And may it please the court. My name is Ivy Johnson, and I, along with my co-counsel, Jay Ferguson, represent the defendant appellant, Mr. Norfolk Jr. Best, or Fuzzy, as he is known to friends and family. In 1993, Mr. Best, an African-American man with a 70 IQ, accused of killing a well-known elderly white couple in Whiteville, went to trial for his life, a trial that had no shortage of issues to litigate. During that trial, an intellectually disabled man faced the death sentence. Black jurors were struck at a rate of 3 times that of white jurors, and the state withheld exculpatory evidence, denying trial counsel the opportunity to present the best defense and denying the jury the opportunity to weigh all the evidence in the case. Mr. Best did not have access to any of the withheld evidence until 2011, because for almost 20 years, the state chose to cheat and manipulate the evidence to best fit their agenda of obtaining a conviction rather than seeking the truth. The state withheld 7 crucial pieces of evidence that touch every aspect of the state's case against Mr. Best. First, the state hid that over 70 unidentified Caucasian hairs were found on Mrs. Baldwin's arm, in her pubic combings, and under Mr. Baldwin's fingernails. Investigators never sought to identify these hairs, and in fact, lied about their existence during trial, telling defense counsel and the jury that no hairs at all were found on the scene. Second, the state withheld that no hairs matching Mr. Best were found at the scene or on the Baldwins. Third, the state withheld that there were 2 alternate suspects, both of whom are white, and both of whom claim to have killed an elderly couple in Whiteville the same weekend the Baldwins were killed. One of these suspects was even seen driving past the Baldwins' home 3 or 4 times before speeding away in the early hours of December 3rd. When he was finally arrested and interrogated in Louisiana on unrelated charges, 3 boxes of his belongings were seized, some of which included bloody clothing and clothing with broken pieces of glass on it. But once again, none of it was tested or disclosed to Mr. Best's trial counsel. Fourth, the state withheld that the SBI conducted extensive fiber analysis comparison of belongings seized from Mr. Best and found they did not have any traces of carpet fibers, blood, or broken glass from the crime scene. Fifth, the state withheld the SBI fingerprint analyst's notes that originally found the ridge detail on the knife was of no value. Sixth, the state withheld that now disgraced SBI serologist Dwayne Deaver found bloody shoe prints at the crime scene, but no blood was found on either pair of Mr. Best's shoes. And seventh, the state withheld that its key witness who testified to Mr. Best having several $100 bills immediately after the time of death originally told law enforcement she had seen him with only $30 or $40. It is important to note that of the 7 items I just laid out, the only one in dispute is the fingerprint and its reliability and characterization. The others, particularly the over 70 unidentified Caucasian hairs, are not in dispute, nor were the hairs even addressed in the state's response brief. The state has not denied that they failed to correct the record at trial, nor that they continued to fight having to disclose this evidence in post-conviction proceedings. The undisclosed evidence touches every single aspect of the state's case against Mr. Best, which essentially relied on 3 pieces of evidence. First, testimony that the ridge detail on the paring knife found under Mr. Baldwin's body matched the left thumbprint of Mr. Best, who is incidentally right-handed. Second, testimony on the weak evidence, forensic evidence in this case, namely the DNA banding pattern on one autorad that purportedly matched Mr. Best and supposedly excluded all Caucasian suspects. And third, testimony that Mr. Best was in possession of multiple $100 bills following the state's proposed time of death, a time that is based solely on the testimony of the Baldwin's daughter as to her parents' nightly routines and not based on any science. The case against Mr. Best at trial is like a three-legged stool, with each leg representing each of the three pieces of evidence relied upon by the state. If one of those legs is cut, the stool begins to wobble, but if the state's lucky, it might stay balanced. If two of those legs are cut, the stool will topple over. Here, all three legs are cut by the undisclosed evidence, leaving the stool to fall straight to the floor. Even if you are unpersuaded by the challenge to the fingerprint evidence, the only fact that remains in dispute, Mr. Best's conviction and sentence cannot stand. A stool cannot balance on one leg, especially if it is meant to hold up a sentence of death. What the state did was manipulate the evidence against Mr. Best to fit their own agenda. The undisclosed evidence goes directly to defense counsel's ability to prepare its case, which is the heart of what a Brady claim is all about. Had the withheld evidence been disclosed, Mr. Best's defense counsel would have been able to present the jury with a counter-narrative and paint the picture of Ricky Winford, a white man seen driving past the Baldwin's home multiple times in the wee hours of the night before speeding off to tell his girlfriend in Myrtle Beach, which is just 40 minutes away, that he had killed an elderly couple in Whiteville. They would have been able to tell the jury that 70 unidentified Caucasian hairs were found on the arms and in the pubic combings of Mrs. Baldwin and under the fingernails of Mr. Baldwin. And that when law enforcement finally caught up with Ricky Winford, they seized bloody clothing and clothing covered in broken glass from his car. Mr. Best's defense counsel was denied the opportunity to present this evidence, and the jury was denied the opportunity to consider it. If you let this conviction and death sentence stand, you are rewarding both the state and the law enforcement officers involved in the original investigation for cheating and cutting corners in order to obtain a conviction at all costs. The takeaway will be that the Brady requirement to disclose exculpatory evidence is something less than an absolute. No person should be convicted and sentenced to death without first getting the benefit of their constitutionally guaranteed right to due process. I do want to address the elephant in the room, the post-verdict DNA evidence. The state concedes the court can't consider this evidence in a Brady analysis, yet brings it up to bolster the otherwise incredibly weak case against Mr. Best at trial. Basically, the state is asking you to overlook 20 years worth of evidence withholding and bad behavior, and to reward them, the FBI, and the Whiteville police for failing to do their jobs by seeking a conviction rather than truth and justice. The post-verdict DNA results are a bad fact for trial counsel to contend with, but the results have not been tested by the crucible of cross-examination, and their admissibility has not been tested by the rules of evidence. It is inappropriate for the lower court or this court to decide the result of any new trial, including the penalty phase, would be a foregone conclusion, especially in light of the mountain of exculpatory evidence the state hid from the defense. Mr. Best's guilt or innocence and whatever sentence he may receive is for a new, fair, and constitutionally sound trial to determine. It's not for this court or the MAR court to decide. What happened to the Baldwins was tragic, but the issues before the court are bigger than this one case. The issues before the court today are about process and the fairness every criminal defendant is entitled at trial. No person should be sitting on death row having been condemned to death after receiving anything short of the full extent of due process at trial. We need a system of justice where you can rely upon the result, because the result was born out of fidelity to the rule of law. You can't have a system that ignores the credibility of trial. This case is about making sure all criminal trials in North Carolina are constitutional and fair. Prosecutors and law enforcement have a duty to seek truth and justice, a duty they did not uphold in this case. Even so, there are constitutional rules that limit the means by which the government conducts its search for truth. One of those constitutional rules requires the state to turn over any and all exculpatory evidence it knows or has reason to know. In our system of justice, we do not allow the ends to justify the means. Even the guiltiest of defendants is entitled a constitutionally sound and just trial. And as the Brady court stated, society wins not only when the guilty are convicted, but when criminal trials are fair. If the evidence against Mr. Best was as overwhelming as the state would have you believe, why was so much hidden from the defense? Mr. Best's defense counsel filed 5 separate discovery motions and were repeatedly told by the state, including in open court before the judge, that they had an open file discovery policy. Yet somehow, none of this clearly exculpatory evidence made its way to the defense. Affirming the lower court's ruling will tell prosecutors and law enforcement the means by which they may seek a conviction are limitless. And with respect to how to conduct a proper Brady analysis, we filed a memorandum of additional authority last week and urged the court to closely read Long versus Hooks. The failure of the lower court to grasp the significance of the undisclosed evidence and the effect it would have had at trial only shows the lower court's fundamental misunderstanding of the application of Brady and its progeny. For 20 years, the state withheld exculpatory evidence from Mr. Best and his defense counsel and failed to correct the record at trial. When evaluating whether the evidence is exculpatory and material, you need only look at the efforts the state went to hide it from the defense. To warrant a new trial, the undisclosed evidence need not prove the defendant's innocence beyond a reasonable doubt, need not even be unassailable evidence. Rather, the defendant need only show the undisclosed evidence has a reasonable probability of altering the trial result, either in the guilt-innocence phase or the penalty phase. Even if this court is unconvinced that any one piece of undisclosed evidence would warrant relief on its own, you are required to look at the cumulative effect of all the undisclosed evidence on the evidence presented at trial. The withholding of the untested, unidentified Caucasian hairs and the fact that the state lied about them at trial should merit relief in and of itself. But there are still 5 other major pieces of exculpatory evidence the state withheld.
I'm sorry, excuse me, counsel, but can I ask you a question about the Brady claim? And I understand you also have an ineffective assistance of counsel claim, but if the Brady claim is framed as whether or not the trial court improperly took into account evidence that came to light after the trial, am I correct that North Carolina courts have not decided that precise question?
Well, the 2 cases that we cite to in our brief are, one is a 10th Circuit case that says exactly that, and the other is a North Carolina case, State versus Howard, in which this court stated that in conducting a Brady analysis and evaluating the materiality of withheld evidence, you have to compare it to the evidence presented to the jury, which would intimate that it's only the evidence at trial and not after verdict developed evidence.
And is it fair to say the 10th Circuit case is the closest factually to this case because that case involved highly inculpatory evidence, that is to say a co-defendant or an unindicted person implicating the defendant in the crime after the defendant's trial, right?
Yes, that's correct.
And in that case, the court said that because that evidence came to light after the trial, it can't be taken into account.
Yes, that's absolutely correct.
But I also want to make sure I understand. The state seems to be implying that the statements in your brief that defendant Norfolk Best has always maintained his innocence is somehow different from him currently maintaining his innocence. What is your client's position with regard to his actual innocence?
My client has maintained his innocence throughout this entire proceeding, and I have a duty to uphold his claim in that regard. A reasonable review of the cumulative effect of the undisclosed evidence in this case would leave no choice but to order a new trial, or at a minimum, an evidentiary hearing.
Ms. Johnson, let's talk about the fingerprint on the knife. Why wasn't that enough? Is your entire argument on that issue the fact that you contend the state did not produce the entire record from the fingerprint excerpt which had the language you quoted in the brief about not significant, but then is later sort of explained away?
Well, Your Honor, I think the fact that there was this original doubt as to the reliability of the fingerprint would be something that the defense could have taken into consideration and then presented as a part of its theory of defense. And with regards to the fingerprint, that in and of itself, it's not required that in and of itself merit relief. There are still these 6 other pieces of evidence that the state withheld, and it is the net effect of all of the undisclosed evidence against the evidence presented at trial that determines a Brady violation.
And the other pieces of undisclosed evidence that you're talking about, are they truly exculpatory, or do they, to the contrary, merely suggest that assuming Mr. Best was guilty, that he had an accomplice?
I think it is exculpatory in that it goes directly to his culpability. And I think the fact that the state failed to investigate the 70 unidentified Caucasian hairs just goes to show that they didn't consider any other theories of the case other than Mr. Best had to have been guilty, and they manipulated the evidence to fit that theory. And a jury will always take into consideration all of the facts and circumstances of a case, both with regards to guilt and with regards to sentencing. And the jury in this case was denied that opportunity.
And just for clarity, am I correct that your position is that there are no circumstances ever that a court can consider post-conviction evidence in evaluating a Brady claim?
That's correct.
Okay. Thank you.
In denying Mr. Best's motion for appropriate relief, the lower court put the cart before the horse. It relied on evidence not available at trial, evidence the court cannot even be certain would be admissible at a new trial, as a means to justify the trial result, regardless of its significant constitutional deficiencies. In its response brief, the state concedes the court cannot consider evidence discovered post-verdict in a Brady analysis, but argues the court's vague assertion that the evidence at trial was overwhelming satisfies the requirement that a court conduct a substantive analysis of the net effect of the withheld evidence on the evidence presented at trial. The state supports this conclusory, bare minimum review rather than the substantive analysis mandated by the Constitution. The lower court continually referred to the post-verdict evidence while failing to point to any other evidence of Mr. Best's guilt, showing the court inappropriately considered this post-verdict evidence in its Brady analysis, regardless of what the state asserts in its response brief. The lower court repeated the hollow phrase, overwhelming evidence, which is the first time a court has ever characterized the evidence against Mr. Best as such, in order to avoid having to do any sort of substantive work in this case. Additionally, Mr. Best's counsel failed to hire an independent pathologist or forensic crime scene analyst to challenge the state's proposed time of death, a situation almost identical to the one the Fourth Circuit found to be ineffective assistance of counsel in Elmore v. Osmond. Time of death in this case is crucial. Mr. Best has a corroborated alibi for the entire weekend of December 1st through 3rd, except for the hour and a half the state claims the Baldwins must have been killed, a time that is based entirely on circumstantial evidence provided by the Baldwin's daughter and not based on any science. Had trial counsel used the resources available to them and hired an independent pathologist, they would have been able to put on evidence that the Baldwins died sometime after 7:10 p.m. on December 2nd. The lower court summarily decided there was nothing trial counsel could have done to eliminate the testimony of the Baldwin's daughter, and thus the failure of trial counsel to hire an independent pathologist did not prejudice Mr. Best. However, Mr. Best has no duty to eliminate that testimony. His post-conviction counsel showed 2 forensic experts disputed the testimony about time of death and instead put the time of death during a period where Mr. Best had a solid alibi, a fact that would have absolutely been considered by the jury during deliberations. While the lower court did also reference the DNA testimony at trial, that evidence was not so persuasive as to render any challenge to time of death not worth making. The state itself ran away from that evidence. In its own closing, the state told the jury that this was not a DNA case. Even so, the court once again put the cart before the horse and inappropriately used the post-verdict evidence to avoid having to do a substantive analysis. I'd like to just take a moment to take this court through what a just and fair trial would have looked like for Mr. Best. Had the state disclosed all the Brady material, Mr. Best's trial counsel would have been able to question the SBI analyst about the unidentified Caucasian hairs found on both Mr. and Mrs. Baldwin, and why neither the SBI nor Whiteville Police Department thought it was important to identify them when Mr. Best is Black and none of his hairs were found at the scene. Trial counsel would have been able to put on evidence of Ricky Winford, a white man who was seen driving past the Baldwin's home multiple times in the early hours of December 3rd before speeding off to tell his girlfriend in Myrtle Beach that he had killed an elderly couple in Whiteville, and before ultimately being picked up by law enforcement in Louisiana, where he had bloody and broken glass covered clothing in his car. Trial counsel would have been able to sow doubt in the minds of the jurors with testimony that none of the belongings seized from Mr. Best tested positive for carpet fibers, broken glass, or blood. Trial counsel would have been able to challenge the fingerprint evidence. And trial counsel would have been able to impeach the state's key witness who testified to Mr. Best having several $100 bills over the course of the weekend, which would have completely undermined the state's proposed motive. Finally, had Mr. Best's trial counsel hired an independent pathologist, as Mr. Best's post-conviction counsel did, they would have been able to put on evidence that the Baldwins had to have died sometime after 7:10 p.m. on December 2nd, when Mr. Best had a corroborated alibi. And at this point, I will save the remainder of my time for rebuttal.
Thank you, Ms. Johnson. Mr. Babb?
Thank you, Your Honor. First, before addressing the claims raised below at the MAR court, I may have misheard because of the technology, but I have to respectfully disagree with counsel's assertion that the elephant in the room, as she referred to it, the DNA, is not.
Mr. Babb, I can't speak for the others, but I cannot hear you.
I am not muted. Can I not be heard?
There's a pretty significant echo, and you sound like you're very far away.
Can you turn your volume up?
My volume is all the way up, Your Honor. Speakers are 100. Excuse me, my microphone is at 100. I can call in with my phone and separate the audio from the computer if that would be helpful. I apologize for the problem.
Is that what you suggest, Fred?
Fred may have already stepped off the call to go into the next one. I'll text him, but I think I'm going to go ahead and pause. I think that's probably the best option right here, because I think we're all having the same difficulty. So
Yes, ma'am. I would recommend him switching to phone. I just sent him an email with the directions on how to do that.
Thank you. Thank you for.
Do you wish to call me at this number, or do I call it? Because there's a setup. You can call me at this number.
So what you do is in WebEx, over the WebEx panel, you click on it so that the icons come up at the bottom of the screen. You click on the icon with the 3 dots in it. You click audio connection. You should then have a field where you can type in your phone number so that you have the system call you.
Okay.
Welcome to WebEx. Press 1 to be connected to your meeting.
Can I be heard now? Is that better?
I can hear better. Can the members of the court hear Mr.
I
Bell
can hear
better?
better too.
That's a lot better.
Yes.
I apologize to the court.
Please don't apologize. Madam Clerk, would you also reset the timer? Thank you.
Is there anything else I need to do to turn off my computer, or is that completely over to the telephone now?
You're on the telephone right
It is
now. There's
completely
no
over to the telephone.
Fantastic. I will try again. Thank you. And sorry for the problems. Before I address the claims raised in the MAR below, I'd like to address what counsel called the elephant in the room, the post-conviction DNA testing. And I may have misheard her because of the audio, so I apologize, but I believe the argument was that this evidence has not been subject to cross-examination. I would respectfully disagree. There was a hearing under 15A269 where both the expert for defendant and the expert for the state testified that the DNA sperm fraction from the rape kit was an exact match. That profile was an exact match for defendant's profile. So it has been subject to cross-examination. The Superior Court ruled it was not favorable, and defendant did not seek review of that. Now,
Mr. Brady, while we're on that topic, though, I don't want to detract from, I know you need to get into your argument, but is your argument that there are any restrictions at all on our ability to consider the post-conviction DNA evidence under Brady?
I think, Your Honor, that's a difficult question, admittedly. I believe that, what can that DNA post-conviction test be used for? I think clearly it can be used to refute the DNA claim, which defendant has pretty much abandoned, or at least all but abandoned, that was raised below. I think also the court can consider it when looking at the post-conviction evidence from defendant about time of death, where the DNA conclusively shows who the perpetrator of the crimes were. In terms of Brady, I acknowledge it puts the court in a difficult question, because there's no, and I understand counsel having to represent our client and not wanting to concede anything to Justice Earle's question, but it puts the court in a different situation where there's a Brady claim, but there's no doubt about guilt or innocence. But I do think, while there may become a case before this court where that question has to be answered, I don't believe this one is such a case because of the evidence. As this court said on direct appeal, the fingerprint identifies defendant as the perpetrator of the crimes. And so I don't think the court needs to address that question. I believe Justice Earles is right that it would be a case of first impression if this court were to the effect on how much you could use it in Brady. And again, there may be a case where that has to be decided by this court. I submit it, this isn't a case where it needs to be decided because of the evidence at trial. Does that address your concern, Justice Davis?
Yes, thank you.
The three claims that were raised below, well, the Brady claim, a NAPU claim on time of death, and a NAPU claim on the DNA evidence. Now, addressing the Brady claim, one thing that about the alternate suspects, addressing that first. Well, excuse me, let me say this. Just the judge below at the MAR court did not determine whether evidence had been withheld or to what extent it had been withheld, and decided purely on prejudice. The order is purely decided on the prejudice prong of Brady of materiality. And so addressing that prong on the three areas of the Brady claim, first addressing the two alternate suspects. Counsel argued to this court about Ricky Winford, how he was seen driving, near the house, claimed to have killed two old people and had bloody clothing on him when he was arrested. But as defendant admits in their brief, in post-conviction, those clothes were tested. Ricky Winford was seized and arrested in Louisiana on 5 December 1991. Those clothes were then sent to North Carolina, and in post-conviction, defendant sought to do a DNA test on those clothes, unopposed by the state, and there was no match to defendants. And that DNA test was done prior to the rape kit DNA test being done, which was also unopposed by the state. Additionally, at trial, so if there had been testing done, there could be no match, as was conclusively proven in post-conviction. But also at trial, at the time of trial, Ricky Winford was excluded as a possible donor of the DNA from the rape kit. And that's on transcript page 1530. Two people were excluded as a possible donor, Mr. Baldwin, Mrs. Baldwin's husband, and Ricky Winford. Destine Harris, the other alternate suspect, was incarcerated from 29 November 91 to 3 December 91. As I'm going to argue subsequently, that the time of death evidence is very strong, and Harris could not have been a suspect. But it's also worth noting that one of the two experts defendant submits an affidavit from in post-conviction to medical experts, puts the time of death Monday night till the early hours of Tuesday morning. That would also exclude Harris. So defendant's evidence in post-conviction is inconsistent and contradictory. But the time of death was overwhelming, the evidence. It wasn't just Miss Baldwin's testimony, although, excuse me, Miss Barlow's testimony, who is Miss Baldwin's daughter. But there was also evidence regarding the newspapers that had piled up on the front porch. But based on the evidence at trial, we have eliminated Harris and Winford. Now, looking at the forensic results withheld, exculpatory forensic results is the claim. As Justice Davis has pointed out, much of the evidence is inconclusive. It's not inculpatory or exculpatory. There's no match of the Caucasian hairs. That's true. Defendant argues the hairs were not compared to Winford or Harris. Well, Harris was incarcerated at the time of the crimes, and Winford was excluded as the DNA donor to the rape kit. The shoe tracks were not linked to Mr. Best. That's correct. Also, defendant states incorrectly in the MAR that $300 bills were found in Miss Baldwin's wallet.
but that's not correct. The money was not in her wallet, but was in her purse, within her checkbook, and what was identified as a Xmas money holder. Testimony at trial was that Ms. Baldwin normally kept $800 in an envelope in her wallet, and the wallet was found empty on the floor at the crime scene. As to the fingerprint, it is true that the handwritten notes read that the print was at no value at this time, but goes on to say, however, major case inked impressions will be needed in order to effect any kind of conclusive comparison. Now, even if there was some impeaching value to the first part of that sentence, I think it is noteworthy that neither at trial nor in post-conviction has there been any argument or affidavit from a fingerprint expert submitted saying that fingerprint is not a match for defendants. That is unchallenged, that conclusion. And again, as this court said on direct appeal, that established his identity as the perpetrator. Turning to withheld theory of motive and identity of Carolyn Troy, that, like the first part of the Brady claim, is not material. It is true that in the first there's a handwritten statement that was taken from Ms. Troy, where it appears to read that she saw him Monday night, the defendant. He was drinking beer, about 30, 40 on him, doesn't know if he rented a room. I didn't, because I didn't have any money. A longer, more detailed statement was taken by the SBI of Ms. Troy that was consistent with her trial testimony. The problem for a defendant in arguing any kind of materiality on this claim is Ms. Tammy Rose Smith, who was a witness called by defendant, was much more damaging to his case because she testified that she saw defendant early on December 1st at Lennon's Grill. Now, December 1st is important because that would be right after the murders occurred, and she testified about about going to Chadburn with defendant, stopping to buy $100 worth of crack cocaine, defendant paying for a room and beer, defendant then buying another $100 worth of crack cocaine. Defendant's own witness was more damaging to defendant's case than was Ms. Troy. In addition, there were 3 other persons interviewed by the SBI who gave statements about defendant possessing $100 bills and using that money to buy crack cocaine. Now, they did not testify at trial, but 2 things important about those statements, which are in the record. One, it would eliminate any thought of an APU claim by defendant on this evidence, but also 2, this was not evidence such as the 10th Circuit case defendant refers this court to about evidence generated after trial. This was evidence at trial, and it's fair to look when you're looking at what the collective effect of the alleged Brady material would have. The state could have put these witnesses on if there was any impeachment of Ms. Troy in rebuttal. The Brady claim is simply there's no materiality to any of the evidence. And going to the NAPU claim on the time of death, defendant does present 2 experts. One expert, Deborah Radish, was chief medical examiner. She testified at trial. His other expert, and Ms. Radish isn't his expert, so to speak, but the one that was hired, Christina Roberts, reviewed the documents. Well, Dr. Roberts does say time of death Monday to Tuesday. Dr. Radish says that it's anywhere from 6 hours to 3 days from the time of the autopsy. The autopsy was on December 4th. 3 days prior would be December 1st. The state evidence shows that the murders and rape occurred after from 11 o'clock on Saturday through the early mornings on Sunday, which is December 1st. So it's right up against Dr. Radish's estimates for time of death. But Dr. Radish also says in that same affidavit, it is virtually impossible for a pathologist and medical examiner to provide precise estimates as to time of death. Now, at trial, Ms. Marlowe, again, the daughter of Ms. Baldwin, one of her two daughters, testified about her mother being on medication. Her mother had a pill box where she took morning, noon, and night. According to Ms. Marlowe, looking at the medicine in the pill box, her mother had taken her medicine on Thursday night, all day Thursday, all day Friday, all day Saturday, but had not taken any medication after Saturday night, the last dose of the day, which was at 11, and that's at page 1263 of the transcript. And she testified that her mother's habit was to fill her pill box on Thursdays. So this wouldn't be a case of it ran out Saturday. She would fill her weekly pill box on Thursdays. She had not taken any medication after from 11 o'clock Saturday night on. Ms. Marlowe testified her father went to bed usually after his wife did. He would normally turn a light on by the sink, and then he habitually rose between 5 and 6 to retrieve the newspaper from the front porch and read it that in the morning, and then placed it on the floor beside his bed and returned to bed. Beside his chair and returned to bed. On the morning the bodies were discovered, there were newspapers on Sunday, December 1st, Monday, December 2nd, Tuesday, December 3rd, laid on the front porch. Now, again, Ms. Smith, the witness called by defendant, testified that on December 1st, she saw the defendant spending money, buying crack cocaine, paying for hotel rooms, beer, and so forth. All the physical evidence at the scene indicated the victims were killed after 11 on Saturday night and before Mr. Baldwin went to bed, but certainly before the next morning. In addition, when defendant is submitting his post-conviction affidavits saying, no, the time of death is different, I believe this court can consider the post-conviction test results from the DNA to show that the post-conviction, excuse me, evidence offered by defendant is insufficient because the DNA evidence refutes the claims about the time of death where defendant could not be the perpetrator. The final claim brought in the MAR was that the state presented false DNA evidence at trial. As I said, that claim is not really argued. At trial, the state's evidence, based on the technology at the time, eliminated 94 people out of 100 for North Carolina's African-American population. It eliminated 997 people out of 1,000 for North Carolina's white population, and the same number for Lumbee population in North Carolina. 997 out of 1,000, excuse me. So that DNA evidence did not eliminate defendant, did point towards defendant, but there's no change in the state's position that, like the prosecutor at trial and closing argument, and like this court on direct appeal, the fingerprint evidence shows that defendant is the perpetrator of the crime. Now, defendant makes in his brief an argument on sentencing, but there was no sentencing argument raised below. There was nothing from the sentencing phase. All the claims are from the guilt innocence phase, and submit that that's not properly before you. This case one other thing to mention, that we don't know what was turned over. I will admit that it would be difficult, if not impossible, to recreate that at this point. From looking at the files, there was no bait stamping. There was no, the state could not show that any of this complained of evidence was turned over at this point. But what can be said is that in the first MAR in 1998, defendant did not ask for discovery until immediately before the hearing, and the trial court held it was he was dilatory and didn't want to delay the hearing, or found it was for the purpose of delay, whatever, and rejected the discovery request. This court did not grant review. Years later, when defendant made a discovery request, it was turned over by the state completely. when defendant made 2 different motions for post-conviction DNA testing. They were unopposed by the state. This is not a case where there's this conspiracy to manipulate evidence, and this is, yes, some evidence we can't document that was turned over. Freely admit that at this point. But looking at this evidence and assuming it wasn't turned over, none of it is material, and there's overwhelming evidence of guilt. There's no other way to say it. There's a bloody fingerprint on a knife underneath Mr. Baldwin's body. The time of death is shown by a pillbox and newspapers and the defendant's activities himself. And this court does not need to consider the DNA evidence and from post-conviction that conclusively shows his guilt in that Brady claim. This isn't the case that it needs to be done on, but it is proper to consider the DNA evidence in rejecting the second and third claims that defendant made in his MAR. Would ask that this court uphold the Superior Court denial of the second MAR filed by defendant. The Superior Court's ruling is consistent with this court's opinion in McCone and was correct in its determination there was no merit to defendant's claims. Thank you.
Thank you, Mr. Babb. Ms. Johnson, rebuttal.
Thank you. At the time of trial, it was material that defense counsel did not know that 70 unidentified Caucasian hairs were found on both of the Baldwin's bodies and at the crime scene, and that when Agent Hamlin was directly asked by defense counsel whether any hairs were found, he stated, and this is on Appendix 133, no hair was found, period. At trial, it was material that defense counsel did not know of the alternate suspects, did not know that the state had a box of evidence of untested clothing, did not know the results of the extensive fiber analysis comparison tests, nor the results of Dwayne Deaver's luminol testing, and it is material that defense counsel did not know that Carolyn Troy originally testified to having seen Fuzzy with only $30 or $40. And I do just want to briefly return to Justice Earle's earlier question and say that my client Fuzzy has always and still maintains his innocence, and the post-verdict DNA evidence has not been tested by the rules of evidence or cross-examination before a jury. And how that evidence is to be considered and weighed is for a jury to decide.
And just to follow up on that, I thought that I saw in the record concerns about this DNA sample having been contaminated and not having been stored properly. Am I correct about that?
Yes, Your Honor, that's absolutely correct. That evidence was stored for many years. We don't know. We didn't find it until 2011 in a cardboard box in an unsealed envelope with other unsealed envelopes and other pieces of evidence from this case in a closet in the attic of the Whiteville City Hall. So there was no temperature controls, no indication of who had ever put it there or for how long it had been sitting there, which would be something to suss out. Yes.
And also, just to be clear, the remedy that you're seeking is that this be remanded for a hearing, correct? That the trial court conduct a hearing on these claims.
Well, in our original brief, we asked for an evidentiary hearing, but in light of the state's response where the existence of this evidence is not disputed, we'd be asking for a new trial, but at the very least, an evidentiary hearing. That's the remedy we're seeking.
Would it be different on the ineffective assistance of counsel claim versus the Brady claim? That is to say, there hasn't been a hearing on the ineffective assistance of counsel claim, right?
That's correct. And the nature of that claim is such that it would be appropriate for an evidentiary hearing, but this court need not even reach the ineffective assistance of counsel claim to find that the constitutional deficiencies of Mr. Best's original trial were such that a new trial is required to remedy those deficiencies.
I have a quick question about the DNA, the post-conviction DNA evidence, Mr. Babb indicated that there was cross-examination at the hearing. What do you say about that?
Well, that was just before the Judge Sasser, the Superior Court judge in Columbus County. It was not before a jury, and it was only for to decide whether it's favorable or unfavorable. It was not a rigorous cross-examination before a jury who would be the ultimate weighers of that evidence. And it has not been tested as to its admissibility. And as Justice Earls mentioned, there are some serious concerns in terms of chain of custody, and we cannot assume that that evidence would even be admissible at a new trial should this court decide to grant Mr. Best a new trial.
So the issues about the storage and whether there might have been contamination or temperature, any of those things did not come up at the hearing before Judge Sasser?
I believe it did come up, but it wasn't fully sussed out as it would have been at trial, and in combating the admissibility of that evidence at trial.
Okay, I understand. Thank you.
And I'd also like to return to counsel's point about the other testimony as to the money. And I think it is important to note that Tammy Smith only testifies to having seen Mr. Best spending money, and she in fact never says that he had multiple $100 bills, which is sort of the crux of the missing money from the Baldwins, and specifically states she saw him spend a $50 bill and then other smaller bills. She just says she saw him spending money throughout the weekend. And with regards to the fingerprint, there is evidence in the record at trial that Mr. Best had used that paring knife while cleaning out the gutters of the Baldwins and had cut himself, which could explain the presence of the fingerprint. But to quote the Fourth Circuit in Long versus Hooks, or to reference their opinion, without a narrative to contrast the prosecution's story, a jury will have little reason to give weight to the defense. And because of the mountain of withheld exculpatory evidence, Mr. Best's trial counsel was not able to present its own story to the jury.
Was the evidence that he had touched the paring knife to do repairs, was that before the jury?
It was, yes. He testified to that at trial. And one of the officers who had done the physical examination of him when he was arrested said that he did in fact have cuts on his wrist consistent with cleaning gutters that could have bled.
But just so we're clear, the jury did reject that argument by its verdict.
I'm sorry, can you repeat that? I had trouble hearing.
By its verdict, the jury did presumably reject his testimony on that point.
That's true, but I submit that it's because the defense was not able to present its best case because of all of the withheld evidence, which is exactly the situation that the court considered in Long versus Hooks. And I just want to emphasize that in deciding this case, this court has to consider the message it sends to prosecutors and law enforcement across the state, and the message it sends to defendants about the fairness of criminal trials in North Carolina. And as Her Honor, the Chief Justice recently said, we must decry the failures of justice and equity as forcefully as we decry violence. I respectfully submit that it is the responsibility of this court to take ownership of how our courts administer justice and to do better. And this case is the perfect opportunity to do better. The failure of justice in Mr. Best's case can be rectified by this court today, and for these reasons, we ask that you remand for a new trial, or at the very least, an evidentiary hearing.
Thank you, Ms. Johnson, Mr. Babb, Mr. Ferguson. Madam Clerk, would you recess us?
Oh yes, oh yes, oh yes. The Supreme Court of North Carolina will be in recess for 15 minutes. God save the state and this honorable court.